Good afternoon, everyone, and welcome to the latest employment law update from Burness Paul. I am Claire Scott, and I'm a partner in the employment team, and I'm joined today by Lisa Byers, who is a director in the employment team. You may not have met us before because we are new to the team, having joined from another firm a little while ago. So we're delighted to be here with you today. We are going to just chat about a few housekeeping matters first, and then we will kick off with the substantive training session. So once you have joined, if you could please just ensure your mute button has been selected to limit the background noise. We do welcome questions, so it'd be great if you've got any questions just to pop them in the chat, and then we can deal with them at the end when we have time. And today's webinar is being recorded, so if you have any questions, please just check out our privacy policy on the Burness Paul website. We've got an hour today, so there should be plenty of time for questions, so we look forward to hearing from you if you've got any. So I'm just going to kick off now, and with the first of my slides, please. Thank you. And that is my part of the talk today is going to be top tips for changing terms and conditions of employment. So in a rapidly changing world, employers are increasingly needing to adapt their businesses for all sorts of reasons. And this can often result in employers needing to make changes to their employees' terms and conditions of employment as well. And we see this a lot. It's an increasing part of our daily work. And a change project, while often necessary, can be fraught with pitfalls. So today I want to talk to you about some tips to try and avoid some of those pitfalls. But a key thing I would say at the outset is that planning and identifying risks at an early stage is going to be key. There have been a number of high-profile change projects in recent years in the press. We can all, I think of these. And the fallout from them has resulted in a new statutory code being introduced this year and promises for future change by the new Labour government. So it's very much a watch this space. It is a hot topic and something to take real care in if you're doing them in your business. So I'm going to discuss my 10 top tips when thinking about changing terms and conditions of employment for existing employees. So tip 1 is identify the contractual terms that we're talking about. Now that seems very obvious, but it's something that we see time and time again, because you really have to work out whether the term you want to change is contractual or not. It's much easier to change something without the consent of the employee where it is not contractual. And this is why many policies in company handbooks and so on will specifically state that they're not contractual and that they're subject to change. And this allows the employer to update the policy for legislation or best practice or business need. However, even where a term in a staff handbook is stated to be non-contractual, an employer could be in breach of the implied term of trust and confidence if it removes a benefit or significantly adapts a policy which is to the detriment of an employee. If the term is in the contract of employment, then this normally means that it is contractual unless it's stated otherwise, but that's not always clear. It really just depends on the term. And it's worth saying that it's not just the written contract which you need to look at. So side letters we often see with perhaps bonus arrangements or a change to contractual working hours, for example, they're all important. We need to look at policies. Exchanges of emails can amount to a contractual change, and even WhatsApp messages and the like can be evidence of a contractual term. The term doesn't even need to be in writing to be in the contract. There can be a verbal contract, although it's a bit more difficult to prove, but it's worth thinking about all of that in the round when you are looking at what does the contract say and what are the contractual terms and can we change them without agreement or not. You should also watch out for terms which are implied into the contract. So, for example, through custom and practice, and I'll give you an example of that. So if you normally, your redundancy policy states that employees will get statutory redundancy pay, but you always pay an enhanced redundancy payment on top of that, and you've done that for years and years, then the chances are the enhanced payment has become a contractual term through custom and practice. And if you then wanted to change that, you would need to approach it as a change to a contractual term. Some employees will have terms incorporated into their contract as well, by usually by collective agreement that's been agreed by a trade union in the past. So it's worth remembering that those are part of the contract as well, if that's relevant to you. So first top tip, identify what are the contractual terms and are you proposing to change them. Tip 2 is check if the proposed change is already authorised by the contract. So some changes are easier to make because you've already got something in the contract which says that you can do it. So there are a number of scenarios that this can arise with. Firstly, you might just look at the contract and the clause, the relevant clause, and say, actually, that's broad enough to accommodate the change which we're trying to make. So we don't need to seek a contract change because the contract clause is already broad enough. So that's the first one. Secondly, there might be an express right in the contract to make the change in that area. So an example of that would be a salary review clause. I mean, most people don't complain when they get an increase in salary, but you would have an express right to do that usually in the contract. And then the third type of clause could be a clause that gives a general power to vary the terms of the contract. So it might say, we can make any change to your terms and conditions by giving you a month's notice. You sometimes see these sorts of clauses. However, there are limitations to that type of clause and you should be a bit careful when using them. Generally, it's more difficult to rely on that kind of general power if you're wanting to make substantive or material changes to the contract. But they are useful to deal with discrete changes, maybe for admin reasons. For example, if you're changing your insurance provider, something like that, you're still providing a particular type of insurance, but you're changing the provider. Those clauses are useful for those sorts of things, but where there are more substantive changes being proposed, you usually need specific agreement. So that's tip 2, check if the proposed change is already authorised by the contract. My third tip is watch out for legislation which governs how to make the changes. So what do I mean by that? Well, there are various bits of law that will override the general approach, depending on the type of change that you want to do. So a couple of examples I'll give you today. The first of those is flexible working requests. So as most of you will know, since the 6th of April this year, employees have had a day one right to make a request for flexible working under the statutory scheme. And there's a whole load of process that goes along with that. So if you get a flexible working request in, you should follow the statutory procedure laid out. Another example is pension reform. So there are regulations dealing with how you should approach pension reform, and they require employers to consult in a particular way with active and prospective scheme members and their representatives where particular listed changes are being made. So you have to follow that bit of the law if it's a pension reform change. TUPE is another area to bear in mind. Making changes following a TUPE transfer can be complex. The incoming employer should have provided the outgoing employer with the details of any measures to consult with the employees in advance of the TUPE transfer. So you usually know what you're talking about, and the employees usually know what changes might be coming. However, any attempted variation to a transferring employee's contract will be void if the sole or principal reason for the variation is the transfer. So this can make harmonisation of terms after a TUPE transfer quite difficult. You can make changes in certain situations though. You're allowed to do it where the sole or principal reason for the variation is what is known as an ETO reason, entailing changes in the workforce. So this could be a reason relating to the profitability or market performance of the new employer's business, and that would be an economic reason. It could be a reason relating to the nature of equipment or production processes, something like that, and that would be a technical reason. Or it could be a reason relating to the management or organisational structure of the new employer's business, and that would be an organisational reason, and those are the ones that tend to crop up the most actually. And changes are also allowed following a TUPE transfer where the contract permits them in the first place. So where you've got an existing clause in the contract which allows it. So an example of that would be where you've got a mobility clause in your contract which allows you as an employer to move employees between different sites in a particular geographical area, for example. So if you're going to operate the mobility clause post-transfer to change an employee's terms and conditions on where they work, that's okay even after a TUPE transfer. So those are the sort of legislative things that I'm talking about in the background. So watch out for legislation in this area. Tip 4 is meaningful consultation at an early stage can be helpful. Now this can be a bit controversial when you're talking about change project with a client. So an employment tribunal will expect to see that an employer has consulted meaningfully with employees before making a change. And it goes without saying, I think, that where there are recognised trade unions, then an employer will need to consult with them in accordance with any collective agreements as well. But I find that many employers are wary about starting consultation unless employees are refusing to accept a change later on. So strategy and approach should be carefully considered right at the beginning of the change project and also kept under review as matters develop. So some changes are not controversial and employees may simply accept them. And other changes are understood to be necessary and in the interest of the employees and the business, and they may also be accepted. So we saw that a lot during COVID, for example, when employers would just issue contractual changes for acceptance with no real consultation and with little resistance because everybody understood the urgency and the need to make the changes. However, other changes can be really sensitive, impactful, controversial. So the best thing in those situations is really to be upfront at the beginning, in my view, about why changes need to be made, and you do that through consultation. So you want to be explaining to the employees through the reps or otherwise the reason that you need to make these changes, exploring through that consultation whether there are any other less impactful changes that can be made, and also looking at ways to sweeten the deal to help get consent to the change, for example. And you can do that through the consultation process, and it can be really helpful because you might think you have to make a change to something, and then during the consultation process somebody brings up an idea which is better than your own, for example. Often though, the consultation process won't really have any meaningful impact on the business reasons for the change, but at least you're trying to take the employees with you and explain the reason for those changes at the beginning, which can really help with the employee relations aspects of this. If employees are not going to accept the change, then the level of consultation is also really important from a legal perspective in showing that as an employer you have acted reasonably, and we'll come on to talk about that in a little bit more detail in a minute. So meaningful consultation can be helpful. Think about it at the start and decide your strategy. 5, consider express agreement against implied agreement to the change. So are you going to go for express agreement? Are you going to go and ask the employee to sign up to the new change, or are you not? So a contractual change requires consent to be effective, and that can be achieved in a number of ways. So firstly, express agreement, where the employee agrees to the change. And an obvious example of that is where an employer issues a new contract for signature and acceptance with a promotion. Fine, nice and easy. However, if you are doing that, the risk is that the employee says, no, I'm not going to sign up to that. I want something else. Secondly, is where an employer decides not to ask the employee to agree the change, excuse me, but instead makes the change and imposes it and relies on the employee continuing to work as acceptance of the change. So you see this a lot where employers will just write out or inform the employees, something's changing, this is happening, and it's happening from X date. And just see whether anyone objects or whether they continue to work on. And if they do continue to work on without objection, then over time, an employer can try and argue that the employee has agreed to the change by continuing to work. So that can work well, that approach can work well, particularly with less controversial changes, but there are risks with it, which we'll come on to discuss. But courts are generally reluctant to find that an employee has consented to a contractual change in the absence of express agreement. So that's particularly the case where the change doesn't have an immediate practical impact. So if a change is only triggered in the future, there's a risk that employees won't complain about it when it first comes in until that future date when they have to rely on it. And it's difficult, therefore, for an employer to say, well, actually, they accepted it, they continued working, and therefore we've got implied agreement. So that can crop up, for example, where there's a change to benefits or sick pay, which the employee may not rely upon until a year or two down the line. So it's really, implied agreement is has a lot of risk attached to it. So think about which approach you want. Tip 6 is do a careful risk assessment before you impose any change. So right at the beginning, when you're doing your planning, you do need to think about which approach you're going to do and what are the risks attached with each and what are the costs attached with each. So if you don't seek express agreement and instead impose the change, you might get the change agreed with minimal fuss and the employees continue working fine, great. However, employees can say, no, we're not accepting that change and we're going to work under protest. And they may refuse to accept the change if it's a change to job duties or shift patterns, for example. They may say, no, I'm going to keep working under my old shift pattern. So you've got that practical issue. They may bring a claim for unlawful deduction from wages if you have changed something which affects their pay, and they may still continue to work while making that claim. And in some situations, they may even claim unfair dismissal while continuing to work. So if the change is substantial and they say it has essentially brought the contract to an end, then they can bring a claim for unfair dismissal, which is a bit of an odd one to get your head around. So you've got risks there. You've also got the risk of resignation and constructive dismissal if a breach of contract is fundamental. So imposing the change can really have risks attached. So your strategy and approach to change will really depend on what kind of change you're proposing, the timing of it, whether they're positive or negative changes, how many people are affected, and whether you can mitigate the impact, and also whether you have recognised trade unions. So there's a lot going on there and a lot to consider. So early planning for different scenarios is really key, and you should take account of the risks of each approach and the costs associated with each scenario. So moving on then to tip 7, which is dismissal and re-engagement. So here, It's potentially lawful, at least for now, and it is a way that you can get through a change if you cannot get agreement. But it's a risky business. So the law does allow for it at the moment, and that would be where you dismiss the employees under the old contract and then immediately offer them re-engagement under the new contract. And you'll probably be aware that that is known in the press as fire and rehire, and it can certainly result in bad publicity, and it can have a major impact on employee relations, even when that approach is legal. It can also, and I've seen this before, it can also result in interest from trade unions. So if you're a business that doesn't have trade unions and you are thinking about using dismissal and re-engagement where you can't get agreement, you often find that someone who you're consulting with might go off and get some advice from a trade union. And if they hear that dismissal and re-engagement is on the table, then they may also try and increase their membership of your organisation. And ultimately, we have seen recognition requests from trade unions as a result of a change programme that hasn't gone well. So lots of different risks there. So dismissal and re-engagement shouldn't be undertaken lightly. It's a last resort. There is a risk of unfair dismissal claims in that situation, but they can be successfully defended if you follow the right process, and we have done this before. There's also a risk of a detrimental impact on employee relations and morale and negative publicity more widely, so it's really something to be careful of. And if you are going to go down that route, you should follow the statutory code when considering dismissal and re-engagement. So the code came into force, as you may have seen, on the 18th of July this year, and it sets out a process for an employer to follow where it's considering making changes to one or more of its employees' contracts of employment. And the steps can be summarised as information sharing, meaningful consultation, raising the prospect of dismissal and re-engagement, re-examination of your proposals. In the draft code, this was quite controversial, and it said the employer should re-examine its business strategy as following consultation, but that wasn't in the final version of the code, which I think is helpful for employers. The re-examination of the plans, though, should take account of any feedback that you get from the consultation. And then you go for unilateral imposition of the new terms and dismissal and re-engagement. So we don't have time today to talk about that in a lot of detail, but the statutory code does set it out. And while it doesn't impose a legal obligation, tribunals are required to take it into account when considering the award of compensation. So it's definitely something to read. I would also say watch out for further changes in this area, because Labour initially said they would completely ban fire and rehire, but they seem to have rolled back from this a bit. And the current position seems to be that they will look to strengthen the penalties in this area, but we don't really know. We're hoping for a bit more detail next week, actually. So definitely watch this space. Tip 8, watch out for the collective redundancy rules if you are proposing to dismiss. So if you're in the fire and rehire, dismissal and re-engagement territory and you're thinking we might have to use this if people don't agree to the changes, then you need to count your numbers. So would you be dismissing potentially 20 or more employees within a period of 90 days at the same establishment? And if the answer is potentially yes, then you need to follow the collective redundancy rules, even though this isn't a redundancy situation in the normal sense. They still apply to a dismissal and re-engagement situation. And you would need to lodge an HR1 form in the way that you would under the collective redundancy rules and follow the particular time periods that are laid out there. And if you fail to do that, then you lay the business open to protective award claims of up to 90 days gross pay per affected employee. So there's a lot of risk there, and something that you should plan for right at the beginning. We have done a previous law lab on the subject of collective redundancies, so you can access that if you are looking for more on this area. Tip 9, we've touched on it a little bit, but it's really consider the employee relations impact in making changes, particularly if you're unable to convince employees of the pressing business need to make the changes. You know, change projects can damage morale and productivity, and they can lead to grievances, claims, sickness, retention issues, and so on. So really thinking in advance about how, as a business, you want to approach this change project is important. And consultation at an early stage, as I've said, can help to identify those risk areas. And really, it gives employees a voice. So, yeah, worth thinking about that in advance. And as I've touched on, also thinking about your risk in relation to trade unions and your industrial relations strategy. So if you've got unions recognised, you really need to try and bring them along with you on the change project, or you will risk industrial action, you know, strikes, working to rule, and so on. You can also risk collective claims. So it's really worth having early contingency planning for strike action, and how you're going to deal with the unions if that is relevant to your business. And then tip 10 finally is get it right at the start if you can. So when you're first putting in contracts, policies, side letters, and so on, really think about whether you're intending for that term to be contractual or not. Do you anticipate needing to change it in the future? And how would you go about that if you needed to? So is there another way to approach the drafting right at the beginning to build in a mechanism for change? And I think that can be really helpful. And we're seeing more employers thinking about the future and thinking, well, we're going to have to be more flexible going forward. We anticipate the world of work is changing, and so we need our contracts to be updated to allow for that flexibility. Also, if you're putting contractual terms in policies, then make it clear which are contractual and which are not. And finally, I would say watch out for side letters and promises made by managers with no involvement from HR or legal. These can be binding, and in our experience, these can be expensive. So really ensure that managers know that they need to involve HR in these discussions. So that's my final top tip for changing terms and conditions. I can see there's some questions in the chat. So what I'll do is I will have a look at those while I hand over to Lisa, and then with the time at the end, we'll try and deal with some of those. But thanks very much, and just hand over to Lisa now.
Great. Thanks, Claire. Well, time's flying by, so I'm just going to push on. There's 3 cases that I want to get through. The first one is USDAW and others, the Tesco Stores Limited. It flows on quite nicely, actually, from Claire, having just covered the changing terms and conditions and, you know, the fab tips that she's just given you all. In this case, the Supreme Court in this case had to consider whether they should reinstate an injunction preventing Tesco from withdrawing a contractual benefit through termination and re-engagement. So in this case, certain employees were offered a retained pay arrangement during a restructuring exercise back in 2007, as an, you know, to avoid losing employees, an incentive to avoid losing employees to redundancy, and also to incentivize them to move into a different role in their place of work. The retained pay was a form of pay protection that made up for any loss of income because of the move. And a joint statement, and this is important, a joint statement at the time from USDAW and Tesco stated, firstly, that the retained pay is guaranteed for life and will increase in line with any future pay increases. It was also critical that the employees' contracts provided that the retained pay was a permanent feature of their contract and could only be changed by mutual consent. It's worth highlighting now that it's quite unusual to see such express wording, you know, relating to benefits. So the wording in this case it's very specific, and you know, it's unusual for us to see this. In January 2021, so this is well over 10 years after the retained pay arrangements had been implemented, Tesco sought to remove the retained pay benefit. To help with that, it offered 18 months advanced retained pay for employees to agree to sign up to the removal. and if the affected employees didn't accept the change voluntarily, Tesco were proposing to terminate their contracts and offer re-engagement on the revised terms. As Claire has said, attempting to change terms and conditions in this way isn't unusual, and it's something that we're often, advising clients on and talking them through that process. Claire's kind of touched on it, but often employers would seek to agree the changes through consultation in the first instance, and where agreement can't be reached, and if there is a good business reason for the proposed changes, an employer can terminate the affected employee's contract, followed by an offer of re-engagement. As Claire has mentioned, this is known as fire and rehire and has received a lot of negative press coverage over the last years. And Claire's talked you through that, so I won't cover it in detail and just focus more on the case here. Generally, in these cases, we would see the affected employee seeking remedy through the Employment Tribunal by way of a claim for unfair dismissal, as Claire flagged. But in this case, the employee sought an injunction, which in Scotland is known as interdict, in the High Court, which, if granted, would have the effect of preventing Tesco from terminating the employment contracts, which was, of course, the ultimate aim here. In the High Court granted an injunction to prevent Tesco from terminating the contracts to remove the retained pay, and Tesco then appealed to the Court of Appeal. What the Court of Appeal looked at was the interpretation of the word permanent, and it determined that the High Court had erred in holding that both parties intended the entitlement should be permanent based on the contractual wording, which seems, a bit odd when you looked at the wording. But the Court of Appeal didn't think that the mutual intention of the parties was to limit the circumstances in which Tesco could terminate the contracts. It felt that the express terms of the contract should be interpreted in accordance with their natural and ordinary meaning, which they considered meant the terms would continue until the contract was terminated and Tesco could give notice in the normal way. Of course, the USDAW appealed on behalf of the employees to the Supreme Court, and the Supreme Court allowed the appeal and restored the injunction, finding in favour of the employees. When it came to their interpretation of the word permanent, it said it could not have been the intention of the parties that Tesco could unilaterally terminate the contract to remove the right to the retained pay based on the wording that was there. It said that it was necessary to imply a term into the employee's contract to the effect that Tesco's general right to terminate the contract with notice could not be exercised to specifically remove or diminish their entitlement to the retained pay. The facts of the case were very unusual, so thankfully we do not see many employers that find themselves in this situation where they've granted permanent rights to a benefit. So the main takeaways from this case, I suppose number one would be, where you're considering termination and re-engagement, is to carefully consider the documentation and communication relating to the benefit, just to make sure, as Claire says in the documents, there's no unusual promises that you're making, which was the case here. And also more generally, it goes back, I think, to Claire's number 10 in her top tips. It's looking at giving careful consideration to drafting in the first instance, and focusing on, well, what we don't, and what we want to be contractual, and what we don't want to be contractual. So that was that case. Moving on to the next one, which is Raymond Cairns v. the Royal Mail Group Limited. This is a case of the Employment Appeal Tribunal, where they determined whether an impending merger was relevant to whether an employee's dismissal due to ill health was discriminatory. So some brief facts. Mr. Cairns was employed in a delivery role at Royal Mail's Hendon delivery office. He was a disabled individual due to osteoarthritis, which prevented him from performing his normal outdoor deliveries. Royal Mail gave Mr. Cairns a temporary indoor role and commenced consultation to dismiss him due to ill health, as he could no longer perform his delivery role, and no permanent indoor positions were available. In February 2018, he was dismissed. He appealed against his dismissal, which was rejected in May 2018, and he was paid in lieu of notice until the 25th of May 2018. Mr. Cairns raised a claim for unfair dismissal and failure to make reasonable adjustments, along with other complaints, and the tribunal dismissed the claims, holding that it was not reasonable for the employer in this case to continue to employ him in the role for an indefinite period, and there was no alternative roles available where there was no alternative roles available for him. He appealed appealed the rejection of the claim for failure to make reasonable adjustments only. So when it comes to the law, Section 20 of the Equality Act 2010 imposes a duty on employers to make reasonable adjustments to help disabled employees, job applicants, and former employees in certain circumstances. The duty arises, as most of you will probably be aware, where the disabled person is placed at a substantial disadvantage in comparison to a non-disabled person by the application by the employer of a provision, criterion, or practice. Where there is found to be such a PCP, the employer must take steps as is reasonable to avoid the disadvantage. On appeal, Mr. Cairns argued that the tribunal had failed to consider the specific adjustment which he said that should have been made, and what he had actually argued should have been made throughout the process, which was that Royal Mail should have engaged him for a few extra weeks until the imminent merger of hand and delivery office with the other, which he says would have created new indoor roles. He had raised the point during the process, in the dismissal process, and had actually raised it at the appeal. At the time of the appeal, it's quite important, at the time of the appeal in May 2018, the merger was expected in June 2018, so it was just a few weeks away. Whilst any indoor roles that would have been created by the merger may from time to time have required him to cover outdoor delivery duties, Mr. Cairns argued that it would also have been a reasonable adjustment for him to not have to cover those duties, given how infrequent they would have been. The Employment Appeal Tribunal agreed, holding that the Employment Tribunal had erred when it had failed to consider whether or not at the date of the appeal it was a reasonable adjustment to continue to engage Mr. Cairns until the merger concluded. So essentially they found that whilst the date of the merger wasn't known at the time of the dismissal, it was only a matter of weeks at the time of the appeal. So essentially it wasn't taken into account, at all at that time, taken into account the circumstances that were relevant at the date of the appeal. The tribunal found and considered that given the change of circumstances at the date of appeal, it may have determined that keeping Mr. Cairns employed until the merger was a reasonable adjustment, particularly given that he was paid in lieu of his notice until the 25th of May 2018. So the EAT didn't substitute a view on it, but remitted the case back to the tribunal to consider that particular point. So the key practical takeaways from that one is, firstly, it's the importance of fully investigating the availability of alternative roles before dismissing a disabled employee. So this will include considering whether there are any impending reorgs, as was the case in this one, which may result in different roles being available that adjustments could be made to, which would make it suitable for the disabled individual. And just emphasising the point that circumstances can change between the point of a dismissal hearing and an appeal and at the appeal stage. And if they have changed, there may be circumstances which have come into play that make an adjustment reasonable at that point that wouldn't necessarily have been reasonable at the time of dismissal. So the final case that I'm going to cover is the case of Turner Robson and others v Chief Constable of Thames Valley Police. This is an employment tribunal decision only, so it's not binding, but it's an interesting one, and it's quite informative because it's certainly worth covering because it touches on the difficulties that can be faced by employers when you're looking to rely on positive action provisions in the Equality Act, and we don't actually see a lot of these cases coming through the tribunal where employers have sought to rely on the positive action provisions, so it's just certainly worth covering. in this case, the tribunal had to consider whether the promotion of a minority employee without a competitive interview process was unlawful discrimination. So the respondent in this case, the Chief Constable of Thames Valley Police, operated a scheme called the Positive Action Progression Programme, which was referred to as PAP. The aim of PAP was to assist candidates at the rank of sergeants who, one, belonged to a minority ethnic group, and two, met certain other conditions to achieve the rank of inspector and subsequently chief inspector. The PAP tried to arrange for additional courses to be provided to officers who were on the programme to assist them to achieve promotion. So in this particular case, the respondent offered a detective inspector position to Miss Sadhu of Asian ethnic minority without taking into consideration for potential candidates. So the three claimants in this case were all white British police officers, raised claims of direct race discrimination against the respondent because they were saying, well, we've been denied the opportunity to apply for this detective inspector vacancy. We get to the law, and under the Equality Act, an individual will succeed in a claim for direct discrimination if the tribunal finds that they were treated less favourably because of a protected characteristic. So in this case, the white British police officers in this case were relying on race. The Equality Act also contains the positive action provisions, which I mentioned earlier, which are a set of proactive measures that an employer can take to assist protected groups which are disadvantaged or underrepresented in a particular job. The positive action provisions are limited exception to the prohibition on discrimination in employment. So the respondent's defence in this case to the claims that were brought by the three claimants were that they operated PAP and their decision to promote was general positive action permitted by Section 158 of the Equality Act. Section 158 of the Equality Act allows employers to take steps to alleviate disadvantages experienced by people who share a protected characteristic, reduce their underrepresentation in relation to particular activities, and meet their specific needs. It also, in the Equality Act, contains a specific positive action power in relation to the recruitment and promotion. So Section 159 enables employers to favour a candidate from an underrepresented or disadvantaged group when choosing between, and this is important, equally qualified candidates for recruitment or promotion. So the provision allows positive action in recruitment as a tiebreaker. The provisions are designed really to create a level playing field without amounting to discrimination, and any positive action taken by an employer under the Equality Act must be a proportionate means of achieving a corresponding aim. So in this case, the tribunal held that offering the promotion to the employee from an ethnic minority without undertaking any competitive exercise whatsoever was unlawful and was race discrimination. The respondent's actions couldn't be held to, or certainly didn't fall within the specific recruitment and promotion provisions under Section 159. And actually, the respondents had denied the opportunity to the other officers to apply for the role and disadvantaged officers who did not share Miss Sadhu's protected characteristic of race. Also, the tribunal found that the respondent had failed to carry out the balancing exercise to their action in the circumstances was proportionate, which is absolutely required with the positive action provisions. So ultimately, the tribunal held that the respondents' actions were not a proportionate means of achieving a legitimate aim. The key takeaways from this one, well, as I said, it's really only a first instance decision, but it is a reminder, for all employers, not to lose sight of what the obligations are under the Equality Act. I certainly found that it shows and emphasises that it's can be quite easy to cross the line from positive action into unlawful positive discrimination, and you need to be quite careful. So whilst aiming to do the right thing and perhaps having the right intentions, you can find yourself falling foul of the provisions if you don't interpret them correctly. And particularly in this case, it was a reminder, or it serves as a good reminder to make sure that all employees and managers within your organisations who make decisions relating to well, any employment related decisions, including those that are related to promotion, have had training, particularly in these sort of circumstances, on the differences between positive discrimination and positive action. In this case, it was found that there was no specific equality and diversity training had been given, and that there was a lack of understanding on the limitations of the positive action, which astonished the tribunal in this case. So I find that quite an interesting one, because, as I say, we don't tend to have it come up that often, but we are seeing a bit of a focus in some organisations looking to see how they can use these positive action provisions. So it just does serve as a bit of a reminder to how to interpret those and the importance of doing that correctly. So that's the 3 cases. I know that we now usually move on to touching on some key legislative changes. So I've got 2 that I'm just going to flag. So the first one that I've got is that from today, employers are going to be required to pass on all tips, gratuities and service charges to workers without any deductions. So this is the Employment Allocation of Tips Act 2023. There is an accompanying code of practice, which also came into force today, the 1st of October, and can be found on the government website. And there's non-statutory guidance also, which I believe was published last week. We are going to be looking to organise a webinar covering this and what it means to employers, where it is most likely going to apply. So if this is going to be relevant to you, your organisation, your business, then you can sign up to that, and the details will be circulated as soon as we know when we're going to be running that one. And then the next one, certainly worth flagging, and I'm sure you'll all already be fully aware of it, is the new duty on employers to take reasonable steps to prevent sexual harassment. This will come into force on the 26th of October, and as I said, many of you will already be well prepared for this, but if not, we recently did run a webinar covering this, which included a template policy, and you can still purchase a copy of the recording on our website as well. And also, it's worth flagging, actually, just at the end of last week, that the EHRC updated the technical guidance on the positive duty, and so that's been released and can be found on the EHRC website, and it highlights some really quite important and helpful points about, you know, what you should be doing or what they would expect to see to demonstrate compliance. So that is really helpful and worth reading. And yes, that was the 2 legislative changes. So I've come to the end of those. Before we go on to questions, I just have one more point to flag, and that's for those that are listening from the lovely Aberdeen area. It's just a reminder that we have our very exciting mock employment tribunal running next Wednesday. That's the 9th of October. And you can sign up on the website or reach out to your Burness Paul contact on that if you do need more information. And in fact, I can see I think it's just been popped into the chat there just now. It's a really good day. It gives you the experience of a real employment tribunal, and the outcome is genuinely not predetermined. So you do get the, well, people wouldn't say excitement, but I suppose the suspense of not knowing what way the judge is going to decide the outcome. So that was it all from me. I know there were some questions from Claire, so I'll maybe pass back to Claire for those ones. And
great, thanks very much, Lisa. And if there are any questions in relation to what Lisa's just talked about, then do just drop them into the chat, because we have got a few minutes. So I can see that Cheryl, thank you for your question, a really good one, which is, what do you do about terms which are of benefit to the employee? So, for example, if you were increasing holiday entitlement, how do you make those changes? It's a really good one. I think mean, technically under the law, you still need agreement for these changes, but the reality is if all you're doing is increasing, a term to their benefit and it's good, then they're gonna agree, and therefore, you might not need to get express agreement in that situation. That's usually one where you would just be notifying them to say, we're adding this additional benefit, for example, this is great and this is what it involves. And they're not going to complain about that. So you would just probably deal with that by way of implied agreement. If, however, it's something which relates to a promotion or a new job role, something like that, then you are usually better just going for express agreement and issuing a contractual change, just so everything is nice and clear. The one thing I would say, though, where it's something that's of benefit to the employee is, and a common pitfall I find, is that employers will think, oh, well, it's okay because overall we're making a number of changes here, but overall it's of benefit to the employee, and therefore we think that they'll just agree to it, or we don't think there's going to be an issue. And I've seen time and again where that's not the case. So yes, the employees want the nice beneficial terms, but if it is part of a package of terms and some of them are not so beneficial, or there's a change which some employees don't like, then you can still get into a real issue and have those risks that I talked about earlier on. And I can think of a situation I'm aware of where there was overall a beneficial package of terms for a particular company, but the employees just didn't like some of the changes that were being made to rotas and things like that, and started talking to a union, and then the union made a recognition request on the back of it. And that was quite surprising to that company because they thought, well, this is overall, these are really beneficial terms. So I think it is worth just taking a pause at the beginning of any kind of change project to think, what are we changing? If it's one positive change to holiday entitlement, fine, you're just telling people about it really, and you're unlikely to get any issues. But if it is part of a package of measures, then I think you need to be a little bit more careful. So hopefully, Cheryl, that answers your question. And I don't think there are any other questions in the chat on oh no, there's maybe one that's just come through from Joyce. Thank you very much, Joyce. When does a reasonable adjustment, such as allowing a disabled person to work from home, 100% become a contractual change to place of work under custom and practice, as the disability is unlikely to change? Okay, so that's a really good question there. I don't want to give you a lawyer's answer, but I might need to, which is it just depends. It'll depend on the factual background to some extent. But if you haven't made it clear that you're doing it for, say, a trial period or anything like that, then I think there is a risk that it is a contractual change to their place of work. So it's going to depend on what was said to them at the start and so on. But that's why it's really important, I think, if you are agreeing a change from the written contract, that you think about it quite carefully and are very specific about the terms in which it applies. But yeah, no, I think there is the risk there that is a contractual change. And ultimately, even if it's not a contractual change, the employee can still raise a claim potentially if you change it for a failure to make reasonable adjustments, etc., for disability discrimination. So I think that is a sort of a risky area. And Lisa, I don't know, you're nodding away whether you've got anything to add on that.
Yeah, no, I was going to make the exact point that you're making about leaving aside the contractual side of it. It's, well, if it's a reasonable adjustment, why is it no longer reasonable if you're looking to change it? What there'd have to be something very specific that you're saying that is change in the circumstance of a disabled employee, I think, to say that would no longer be a reasonable adjustment if it had been put in place and agreed to for that reason in the first place, Claire. So yeah, it was just to make that exact point.
Lisa.
Yeah.
And then I think we've got time for one more that Alison has dropped into the chat just now. Thanks, Alison. Is there a rule of thumb for how long something has to have been happening for it to be considered that the custom and practice has become contractual? It's a difficult one. Again, it does depend on the facts and circumstances and what you've been doing. But as a rule of thumb, I mean, it can be shorter than this, but I think if you've been doing something for a year or more, then chances are it's been contractual. I have seen arguments raised that something that employers have been doing for many years is not contractual. So it really does depend on what was said at the time, what policies say, how it operates in practice. But I think the longer you do something, the more likely it is to be contractual. I mean, on the redundancy payments point, this is one that often comes up. I think that tends to have to apply for a bit longer because most businesses aren't always making redundancies. So if you last had a batch of redundancies 3 years ago and at that time you applied an enhanced payment, that doesn't mean that the next time in 3 years' time you have a contractual term of an enhanced redundancy payment, because if you haven't had any redundancies in between. But if you are continually making redundancies, every couple of months, for example, in a large business, and you always apply an enhanced redundancy term, then that's more likely that is contractual in a shorter time period because you're doing it more often. So it does just depend. But yeah, the longer you do something, the more likely it's going to be implied into the contract. So I think we have come to the end of the session now, and that's 1:30. I think there are a couple of questions coming through that we haven't had time to reply to, but we will follow up on those separately. And thank you all very much for attending. It's been great to have you here today, and we look forward to seeing you on the next one, and hope you all enjoy your days. Thank you, and that's the end of this session.